as was just mentioned, I am a criminal defense lawyer. I am one of the lawyers for Brianna Waters, who is facing a trial in February of 2008 in federal court for allegedly participating in a fire at the University of Washington Center for Urban Horticulture in 2001. My client is a 32-year-old mother of a 2-year-old. She lives in the Bay Area. She's a violin instructor. She's not guilty. I can't really talk too much about that particular case tonight because it is pending trial. But I do want to talk more broadly about what has been labeled as the Green Scare cases, hearkening back to the Red Scare of prior generations. And really what this is the intimidation of dissent when it comes to environmental protests, protests against biotechnical research, protests against genetic engineering. And what we're seeing over the last couple of years is kind of the federalization of criminal prosecutions of activists who, in prior years, may have either been within their free speech rights or may have committed crimes that were prosecuted at the state level. But what's been happening in the past 10 years is this incredible federalization of law enforcement where it comes to prosecution of environmental activists and other activists concerned about biotech or genetic engineering. And just recently, this past summer, I was reading a lot about the civil rights movement. I was reading Taylor Branch's wonderful trilogy called America in the King Years. Fascinating set of books about the civil rights movement. And it struck me that 40 years ago or 50 years ago, it was well near impossible to get the federal government to conduct criminal investigations into assassinations, church bombings, intimidation of voters throughout the South. And the response was that, well, these are local crimes, these are state crimes, and the states are well equipped to deal with this. We now cut forward 40 years or 50 years, and we see incredible amount of federal resources going into prosecuting crimes that really have not hurt anyone. Many of the environmental, quote, eco-terrorist crimes have targeted only property. And I'm not saying that that's a good tactic, that one ought to go out and destroy property, but we are talking about property only. We're not talking about church bombings where children have been killed, as occurred throughout the South for many years. We're not talking about assassinations. We're not talking about guns. We're talking about property crimes. Property crimes that really ought to be prosecuted at the state level and not at the federal level. I guess despite my politics, as a lawyer, I feel like I'm very cautious and I'm very conservative. And if I had to advise someone who was going to go and protest against one of these biotech labs, I would tell them to be very, very concerned about being labeled as a terrorist. And I would be very concerned that, that someone would end up with a federal prosecution on their backs. Because as I said, over the past decade, I've seen cases where people ended up in federal court who never would have thought, you never would have thought that they would have been there. Now, just as an example, about 2 years ago, well, let's back up. In the late 1990s, there were a series of fires set throughout the west of the United States, targeting perceived enemies of the environment. Also, there were fires at some animal or institutions that were perceived to be enemies of animals. So there were some wild horse facilities where the Bureau of Land Management was rounding up wild horses and slaughtering them and selling the horse meat to France. I've never tried horse meat, but apparently in France it's a delicacy. There were some fires at slaughterhouses. There was a fire at a ski resort in Vail, Colorado. And there clearly were criminal acts that had taken place. These clearly were fires. These clearly were criminal acts. But for many years, the federal government didn't know who did these things. And finally, 2 years ago, in December of 2005, there were a series of arrests, a series of indictments in districts ranging from Seattle down to California, Colorado, but mostly centered in Oregon, where 12, 13 people were indicted in Eugene, Oregon, for a series of these arsons, which the government alleged were committed by this group that called itself the Earth Liberation Front or Animal Liberation Front, depending on which target was being targeted. And again, clearly there were these fires, and clearly there were crimes committed. But these people who were charged in federal court with federal offenses, which carried incredibly stiff mandatory minimum sentences, so that the mandatory minimum sentence for committing one of these fires was 35 years. And that's a mandatory minimum that the judge, if the person was convicted, the judge could not go below that mandatory minimum. If the person was convicted of 2 of these fires, they would face a mandatory minimum of life in prison without the possibility of parole. That is incredibly stiff for a property offense, for something that should have been a state prosecution for property. 35 years for one, life for 2. And that's not, and the way the statute works is not even like you do one, you get out, you commit the second one, you get life. That's 2 separate crimes prosecuted at the same time for 2 separate fires would be the mandatory life sentence. Now, none of these people were explicitly charged with terrorism, although the prosecutor, after a number of people reached plea agreements to less than the mandatory minimum, the prosecutor wanted to enhance their sentences under the federal sentencing guidelines because of an allegation that these were federal crimes of terrorism. The mandatory minimums actually were due to the allegation that destructive devices were used to commit these arsons. And this particular charge under the United States Code was added to basically to deal with the drug war. So if you committed a crime of violence and used a destructive device, which includes firearms, includes bombs, anything like that, you get this mandatory minimum, the incredibly stiff mandatory minimum. Now, faced with these stiff mandatory minimums, the people in Oregon, well, a number of them immediately folded and started cooperating with the government. And it's like, well, I mean, generally, who could blame them facing life in prison? But what's interesting, though, is that what we saw in these cases in Eugene is really no different than what you see or what we've become used to seeing in the federal system for just about any crime, but particularly for drug offenses. Because the sentences in drug cases over the last 20 years have become incredibly draconian. And normally in any federal prosecution, any federal drug case, there's an incredible pressure placed upon the client, on your client if you're defending them, but on the defendant to quickly turn and cooperate with the government and get a reduction under mandatory minimums. Because the mandatory minimums are just outrageous in some of these drug cases. So the lessons that the federal government learned in the 80s and 90s in the drug war context have translated over into the, quote, eco-terrorism context. And the same types of pressures that were brought to bear on drug dealers or people who were involved in drug operations have been translated into this arena. Before these indictments came down 2 years ago, there were years of government investigation, federal government investigations of these arsons, which focused primarily on political activists who turned out weren't involved in any of these arsons. Many people over time were called before grand juries. There were search warrants executed. People's computers were seized. Their houses were searched. There were informants with wires, working, in the various political arenas. There were people who were political activists who were labeled as domestic terrorists, even though they had never been charged with any type of criminal activity related to terrorism. And I recently discovered this just looking at some NCIC records. The NCIC is the FBI's criminal crime computer system, where so if you're driving down the street and you're pulled over for a speeding ticket and the police officer enters your name into the computer that's linked up with the FBI's NCIC system, they can see everything that you've been charged with. And that's, I guess, in some respects, it's useful if you're a police officer and you want to know if the person that you pull over has a warrant out for their arrest, or if they're, have gun crimes in their past or something like that. But what you see on some people, even though they've never been convicted of any type of terrorism crime, they are labeled on the NCIC screen domestic terrorist. And that's pretty frightening, because that's an administrative label that the FBI assigned to someone that's put into this crime computer, and the person doesn't even know that they've been labeled as a domestic terrorist. They're pulled over by the police because their taillight is out, and the police officer sees coming up on the screen, domestic terrorist, treat with caution. Don't disclose this to the person that you pull over, but notify the FBI immediately. That's very scary. And that's some of the things that were going on over the past 10 years before these arrests took place. At the same time that the Eugene indictments came down, it was about 2 weeks before the New York Times broke the story about the NSA wiretapping and the NSA data mining that had been going on. And 2 years down the road after the disclosure in the New York Times of this program, we really still don't know all that much about what happened, because the government won't tell what happened. What we do know, I would suspect that there was NSA spying in these Green Scare cases. I can't imagine that there wasn't, given the fact that the federal government labeled these people as domestic terrorists. There were also allegations that people came across the border from Canada, so therefore you have this international component. But what we do know is that in Oregon, the first 8 people in Oregon pled guilty fairly quickly. There were 4 defendants down in Eugene who held out and were going to go to trial. And they made a motion for disclosure of any NSA wiretapping information. Actually, Seattle's own Jeff Robinson and Amanda Lee were the primary lawyers who filed this motion. And they filed a great brief down in Eugene on behalf of one of the defendants down there. The judge in Eugene, Judge Ann Aiken, ordered that there be a response by the Department of Justice to this motion by someone in a position to know whether or not there was wiretapping. Because the local U.S. attorney said, well, we don't know if there's any wiretapping that was going on. Interestingly, there was an alleged terrorism case in Oregon where there was a fundraising organization that allegedly was raising funds for an overseas Islamic charity that was first prosecuted in federal court. And then after the federal charges were dismissed, there's been a lawsuit filed on behalf of this organization against the federal government. And the federal prosecutors in Eugene denied that there was any type of wiretapping or anything like that that had gone on. And by mistake, there was an error by the FBI, and by mistake, the FBI disclosed to one of the lawyers in this case down in Portland actual evidence that there had been NSA wiretapping of conversations between this charity in Saudi Arabia and its lawyers in the United States. And when this mistake was disclosed, the FBI swooped down. They wanted all the information back. They wanted protective orders that required the lawyers to not disclose what they had seen already. It was kind of surreal. And that's one of the cases, the lawsuit based upon that was up in the Ninth Circuit recently, where there really is evidence of NSA wiretapping in that particular case. So when Jeff Robinson and Amanda Lee made their motion for disclosure of NSA wiretapping information, and the judge down in Eugene ordered that someone in a position of power or someone in a place who actually had knowledge respond, the government quickly wanted to settle those 4 remaining cases. And the 4 remaining defendants pled guilty way below the mandatory minimums with a very unusual non-cooperation agreement. Instead of cooperating with the government, they agreed to go in and disclose everything that they themselves had done without naming anyone else, which is a very unusual agreement. And that's how those 4 remaining cases down in Eugene were settled. And it certainly appears that it's settled with in such a favorable way because of the fear that some judge was going to order the Department of Justice to disclose something about the NSA wiretapping operation. Unfortunately, when we filed the same motion up here, and I confess that I liberally cribbed from Jeff Robinson's and Amanda Lee's brief, our judge denied our motion. So we still don't know whether the NSA was involved in looking at any of these cases. But my guess is that they probably were, although I've never seen any hard proof of that. But you know, even the people who ended up pleading out down in Eugene are still facing, or still received, incredibly severe draconian sentences for property offenses. I mean, the sentences range from 3 years to 14 years. With some of the people who actually cooperated with the government most getting some of the higher sentences, interestingly. But these sentences are just outrageous, really, when you're thinking about property. Even outside that context of the Eugene cases, there was a case in Seattle a few years ago of a young kid, early 20s, late teens, who set a fire at the McDonald's by the Space Needle. And according to the court record, I don't know anything about this case other than what I read in the court file. He was basically a drifter kid who set the fire in the name of the Animal Liberation Front to impress girls. And he got 8 years in prison. It did minimal damage. Again, I'm not saying that this is an appropriate thing to do, but 8 years for something like this for a young kid who obviously had mental health issues is just outrageously extreme. And again, he was facing an incredibly long sentence, and he pled guilty. Then there's a case of the Shack 7. The Shack 7 is a group of 6 animal rights activists and the organization Stop Huntington Animal Cruelty. All these people are animal rights activists who are now in federal prison after being convicted last year in a federal trial in New Jersey. They were convicted of violating the Animal Enterprise Protection Act of 1992, which is a federal statute that was little used up until recently, that makes it a federal offense to cross state lines or to use mail or the internet to cause physical disruption to the functioning of an animal enterprise by damaging or causing loss of property. It's a very vague statute, little used up until recently. Basically, from what I understand, these 6 people had a website where they put some things on the website that were fairly, I mean, I would say they were encouraging the harassment of the executives of this organization that was doing animal research. But it was just a website. And no one alleged that these individual people did anything themselves. And yet they were convicted in federal court and are serving federal sentences for something that I used to think was protected by the First Amendment. I mean, you used to be able to stand up in front of a crowd and talk about stuff without facing federal prosecution. Actually, when I say used to, maybe 20 years ago. 50 years ago, you probably would have been prosecuted for doing that. But these people are in federal prison for exercising free speech rights. Their cases are on appeal, but they're in prison pending appeal. And again, being a cautious attorney, if someone came to me and said, hey, we want to set up a campaign to cause as much trouble as we can to these people running these laboratories, I would tell them, look at what happened to these people and be very, very careful about what you say so that no one can construe anything you say to be a violation of something like the Animal Enterprise Protection Act. There's an activist just recently who was on trial in San Diego, a guy named Rod Coronado, who actually the jury hung in his case, but he was charged with essentially making a speech where he made a speech apparently about the building of incendiary devices, and then that night someone, they never found out who, went and set some fires at some townhouses that were being built, and he was charged with federal law violations for making a speech. The jury hung in this case. I'm not sure what's going to happen. And the net effect of all of this really is to chill freedom of speech. the government investigations of these crimes, and there are as I said before, there clearly were these fires that were set, but the government's investigations of these crimes centered first on lawful political activity. They centered on political activists who had done nothing wrong, but merely voiced their opinion, and that's where the government began its investigations. The federal label of terrorism justifies spying on people. It justifies wiretapping. It justifies the reading of emails. There's grand jury harassment. The government can send in agents provocateurs. There's a case down in California, I think his name is Eric McDavid, of a young kid who apparently plotted to do some property damage in defense of the environment. But basically, there was a government provocateur who led him down that path and kind of got him involved in some of this stuff. And from a lawyer's perspective, whenever there's a case that involves allegations of terrorism, I get worried because I get worried that someone's listening to my conversations with my client, that someone's listening to my conversations with my co-counsel. The internet is great, to send versions of pleadings up and back to one, from one lawyer to the next. But I have to seriously think about what I'm going to send up and back on the internet if I know that the government may be spying on me because I'm working on a case which they consider to be domestic terrorism. And then there's the case of Lynn Stewart, a lawyer, a guild lawyer in New York City, who was prosecuted and was convicted because she broke Bureau of Prison regulations and her agreement, basically, with the prisons by repeating something her client has said to her that she then told to the press in a news conference. And she was charged and had to endure a federal trial where she was labeled a terrorist and an accessory to terrorists. And I think that's, that has to be a warning for us as attorneys that, if there are these cases that we take on, which we have to take on, that we have to be concerned also about ourselves, representing the people in these cases. So overall, I mean, you see kind of this gradual erosion of civil liberties, an acceptance of things that 20 years ago we would never have accepted. I mean, the fact that we just kind of accept that someone could be looking at our emails. That's, of course, 20 years ago there wasn't email, so I guess maybe, I don't know. But anyhow, I think that the danger is that there's just this erosion of civil liberties whenever the government starts talking about terrorism. So, thank you.